Hello, everyone. My name is Dr. Kyle Livy. I'm a professor of history and co-director of the Lytton Center for History and the Public Good. On behalf of myself and my fellow co-directors, Dr. Heather McCarty, a professor of history, and Dr. Catherine Michael, a professor of political science, I'm excited to welcome you to the our first event in our speaker series this fall semester. And it looks like it's going to be a really exciting event. I'm going to do a few housekeeping things. And the first thing that we like to do is to share our mission. And our mission is really excellent. So I'm going to read it to you. The Lytton Center considers ways that the study of the past can help shape the present and the future. Our mission is to inspire the Albany community to work for the public good through programming focused on access, equity, inclusion, justice, and service. The Lytton Center explores challenges facing our community and the world, past, present, and future, and fosters big ideas that will inspire and transform Albany and the larger community for the better. Through training, programming, and capacity building, the Lytton Center empowers students to advocate for a just and equitable world. So today, we're really excited to welcome our speaker, and Dr. Catherine Michael will do that in just a moment. We want you to engage with our speaker through asking questions and engaging in dialogue during a Q&A following the presentation. And you can do that by using the Q&A feature at the bottom of your screen. So please participate, engage, ask lots of great questions. We'll be asking those questions for you. But now I want to pass things over to my colleague, Dr. Catherine Michael.
Thank you so much. So I am here to introduce Dr. Julie Novkov today. But first, I just want to welcome Julie back to Albany College's campus. She actually joined us last year as part of our People, Place, and Power speaker series. And so I will be doing a similar introduction as I did last year. So Julie Novkov is the interim dean of Rockefeller College of Public Affairs and Policy, and a professor of political science and women's, gender, and sexuality studies at the University at Albany, State University of New York. Her research and teaching are situated at the intersection of law, history, U.S. political development, and subordinated identity. She studies law as both a system of political and social control and as a site for reform through activist pressure. She's particularly interested in the way that the law defines and translates categories associated with identity, such as race and gender, and the ways that these categories transform and are transformed by legal discourse. We're so thrilled to have her here with us again today, and so I'm going to hand it over.
Thank you so very much. Thank you so much for the invitation. I'm very grateful to be back with you. It was wonderful to be with you last year, so I was thrilled to be welcomed back again so kindly this year. And I'm so glad to have heard your mission statement, because we're doing strategic planning in my college this year, and I might have just gotten a few ideas. So with your permission, I am going to share my screen. I have a PowerPoint that I put together that I think will help us on this journey through what's going on with the US Supreme Court and how that relates to American democracy. So just a minute, I will try to get this going correctly, which is always a challenge for me. But if I've done this right, you should be able to see the PowerPoint on your screen now. So we're ready to go. You'll note that the title is a little bit of a play on words.
Excuse me, Julie, I'm sorry, we actually don't see the PowerPoint.
Oh, you don't see it, okay. Let's see, let me try to get out here again. Oh, you know, it would probably help if I actually share the screen. Thanks, I'm just not super. Okay. Let me try again.
Okay. Yes, we see it now. Thank you.
All right, great. Thank you. I appreciate the help. So the title of the talk is a little bit of a play on words. Whether American democracy where is it going if we have an H in there, or maybe are we in trouble if we have it the way that it is written? And I'm hoping that we can explore this question together by looking at the Roberts Court and how it has operated over the last couple of years, and in particular, some of the things that it has done this past term. And the big question I want to ask really is this court fundamentally doing something different than we have seen with the Supreme Court in the past, if we look at historic courts? And I think once we go through what's been happening, where I end up at least, is that maybe it's not completely unique, but it is certainly distinctive in the things that it is doing. It is a heavily polarized court. Usually in Supreme Court history, if you look at the justices and look at their ideology, what you're going to see is you'll have some justices that are pretty conservative, some justices that are more conventionally liberal, and some justices that are in the middle. But right now, what we have is a very distinctive split between the liberal justices, Sonia Sotomayor, Elena Kagan, and the newest justice, Ketanji Brown Jackson, and the conservative members of the court. But even within that conservative, the 6 conservative justices in that block, they themselves seem to be somewhat divided. And what we see right now is a kind of ultra conservative bloc composed of Clarence Thomas, Samuel Alito, and Neil Gorsuch. And then the ones who were a little bit less conservative would be the Chief Justice, Amy Coney Barrett, and Justice Brett Kavanaugh. They're also in some ways more partisan than prior courts. And we'll see that particularly when we look at their cases involving voting rights. They have tended often to reinforce Republican partisan initiatives, which is an interesting development. And they are operating in an environment of historically strong judicial authority. There have been very few periods in American history when we have been turning more to the US Supreme Court to decide major questions about politics and about the direction that the country is going. And the court has been very willing to step in and address those issues in some major ways that have been at times transformative. So, why do the court and perceptions of it matter? So, okay, we have a court that's doing a lot of interesting things, but why should we care? Why should we perhaps be concerned about this? If you look at my home discipline of political science, what we have tended to observe is that the court often tends to be more of a follower than a leader in terms of its role in national political development. So the so-called political branches, the executive branch and Congress, will go out and set agendas, and then the court will either collaborate with those agendas or maybe tweak it around the edges. But we are seeing the court doing a little bit more direct leading under the circumstances that we see right now. And right now, some of what they've been doing seems to be somewhat unpopular. In fact, based on a study done this summer, by the summer of 2023, the court's favorability rating had fallen to a historic low of 44%. And its unfavorability rating, which became quite high after the Dobbs decision in 2022, has remained quite high at 54%. This is leading some people in political science to ask questions about, well, are people's perceptions of the court and what it is doing beginning to catch up with what the court is actually doing? Because over the last few years, the court has been pretty conservative for a while now. I don't think anybody would characterize the Roberts Court as anything but conservative. But if you looked at public opinion surveys maybe 10 years ago, people would say, oh yeah, the court is our favorite of the 3 institutions of government, and they perceived it as being pretty middle of the road. But now very few people, if you ask them, will say, oh yeah, the Supreme Court's a liberal institution. And they will also not say the Supreme Court is a kind of middle of the road institution. They're perceiving it as being more conservative and more politicized. It's also worth noting the interesting fact that several of the justices on the court right now, including the 3 justices who were nominated by Donald Trump, were nominated by presidents who did not win the popular vote in their elections. So that is, it is something of a historical anomaly to have judges in place who are in that position. So before I talk about the 2022-2023 term of the US Supreme Court, I think we want to pause for just a minute and think about what happened last year in the cases that the court mostly accepted in 2021 and decided in 2022. Again, if you look at Supreme Court history, there have been years in the past when the Supreme Court has had a kind of blockbuster term where they've issued a lot of major decisions that have created a lot of controversy among the public. But what has tended to happen in the past is they will have one of these kind of blockbuster terms where there's a lot going on. But then they will follow that term up with a consolidation term where they pull back a little bit. They don't take as many controversial cases. Or if they do take controversial cases, they will decide them in less controversial ways, maybe looking at statutes rather than the Constitution, or writing their decisions narrowly so as not to be as broad and impactful. But let's take a look back on that crazy year, 2021, 2022. Everybody who remembers the major landmark cases that took place then. And some of them are already having some very significant consequences and changing the way that policy works at the state level. The Dobbs decision, of course, overturning Roe versus Wade. You have on the screen here, if you're able to see it, some measure of what has happened since the Dobbs decision went into effect. State legislatures immediately accepted the invitation to regulate, to restrict abortion, sometimes quite drastically. If you're able to see the colors here, the states that are in bright orange, many of which are in the Deep South, but also in the Mountain Midwest and West, they have gone toward very serious restrictions amounting to bans or total bans on abortion. And it's worth noting the impact that this regulation has had on states that border states that have these really serious restrictions. So if you're in Alabama, for instance, or Georgia or Mississippi, you might be traveling to Florida for abortion services. People in West Texas will go over to New Mexico. But if you are in a place like East Texas or Louisiana, it has become quite difficult to secure abortion services. And beyond that, we're seeing the energy behind Dobbs going over into other policy areas, most notably contraception. There has been a controversy over medical abortion too. The drug mifepristone, which was approved by the FDA for medicated abortions more than 20 years ago, has come under scrutiny. And there was a district court judge in Amarillo, Texas, who basically tried to pull out authorization for the use of that drug entirely. That decision was walked back a bit by the Fifth Circuit, but it is still a live issue. And then another case that's had a major impact was the court's ruling in Bruin, the Second Amendment case that struck down a New York gun control law. Some scholars have described this as the most radical case of the 2021 term, not just because of the outcome, but because of the approach that the court took in deciding that case, saying that if you want to determine whether a regulation on guns is acceptable under the Constitution, you have to go back to the founding and think about whether that regulation would have been recognized or acceptable at that time. And courts have used this method to invalidate regulations. There was a ban that a state had passed on guns that have had their serial numbers removed, and that ban was struck down. And then most notably in a case that is likely to go to the Supreme Court in the near future, a red flag law allowing states to restrict gun ownership by people who've been convicted of certain crimes or who have orders of protection against them. That was struck down as something that would not have been acknowledged as legitimate during the founding era. Another major area that the court jumped into in 2021, 2022 was the area of the authority of administrative agencies to pass regulations. If you were paying attention, or if you heard my talk last year, you will remember me discussing this major questions doctrine, or the idea that if an administrative agency is doing something big or impactful, it really has to be able to point to the place in the congressional statute that allows it to do that. And if that specific authorization isn't there, then that administrative action can be called into question. And we're seeing more questioning of regulations on the ground that they're not specifically authorized by Congress. There's been some political fallout for the court as well. As I mentioned earlier, people disapprove of the court at a higher level than we've seen in recent history. There was also a presidential commission appointed to study the Supreme Court and the possibilities around limiting its power. And just generally, there's been a lot more attention around the courts, not just the US Supreme Court, but state courts as well. In April, the state of Wisconsin had a judicial election for their high court. You may know that some states, rather than having an appointment, do elect their justices. And there was a bitter battle over that seat on the Wisconsin High Court, and whether it was going to be taken by a conservative Republican or by a liberal Democrat. And that election wound up costing $51 million in advertising, which is just shocking for a judicial election. So people are really paying attention. So what then is going on in 2022, 2023? Let's look at the numbers just quickly to try to figure out, well, are they going to have another blockbuster term here, or are they going back a little bit more to what is a normal kind of operation for the Supreme Court? One thing that was striking for court scholars last year was that the court really did not decide as many cases by a 9-0 margin. Now, the cases that are controversial usually get more of the attention, often because they are the major cases. But ordinarily what the court does, they'll take these cases and many of them are just going to be 9-0 votes. If you are able to see the graph that I have here, you'll see that 2021 term as a real outlier when that top line, the dark blue line of 9-0 decisions dipped below the 6-3 gold line. And that was an anomaly. But if you look this year, you'll see, okay, we have a lot more majority decisions that are coming out with a 9-0 vote. In fact, 48% of the decisions this year on the merits were 9-0. However, the court remains divided, and that 6-3 margin remains pretty significant. That 6-3 was 21% of the cases. Actually, it was a little bit less than that because Ketanji Brown Jackson recused in one of the affirmative action cases because she had been involved with Harvard, but she would have voted with the dissenters in that case. So I'm counting her as part of that 6-3 line. The 5-4 decisions, which is the lighter blue line, came in at 12%. 7-2 picked up a pretty healthy at 10%. And there was a drop in the number of 8-1 decisions this year. So you didn't have one cranky person kind of sitting out there ruining the unanimity for the court. But one thing that this chart doesn't tell you that I think is really interesting is that the court only decided 58 cases on the merits. That's a really low number. And we might want to try to figure out what's going on with that. If you look at those 6-3 rulings, you'll remember at the very beginning, I mentioned that there's this ideological divide on the court with 6 conservative justices and 3 liberal justices. Of those 12 cases, 6 or 5, you don't count the Harvard affirmative action case, were that straightforward conservative liberal split, right? So you had 6 conservative justices voting for the majority, and then 3, or in the Harvard case, 2 of the liberals in dissent. However, you had 3 cases which were really interesting, where you had that middle conservative bloc joining with the 3 liberals to reach the outcome. So it would have been Sotomayor, Kagan, and Jackson being joined by Interim Barrett, the Chief Justice, and Justice Kavanaugh, with the hard right being the 3 justices left out in the cold. And of those 5 rulings where you had one cranky person sitting off in the corner, the cranky person was Justice Thomas twice, Justice Alito once, Ketanji Brown Jackson in the Glacier Northwest case, and Neil Gorsuch in Lac de Flambeau Bond, which was a Native American law case, about which more a little bit later. Not too surprising to see him on the edge of the court in that type of case. So what happened last year? What was going on? I'm going to talk about a couple of different categories of cases. The first category will be the cases that addressed identity and discrimination. And there were some kind of mixed outcomes here. In 303 Creative, this has some important implications for the future of the First Amendment for the court. Many of you who follow the court and news about the court know that this case involved a website designer who went to court because she did not want to be required to create websites for same-sex weddings. And she sued preemptively so that she could not be required to make these websites. At the time that this suit was brought, she was not actually creating any websites. She wanted to have a statement on her business's website saying that she does not serve this population. And the court ended up ruling in her favor. So at this point, if you go to her website, look into the information, what you'll find is this statement: because of my faith, I'm selective about the messages that I create or promote. While I will serve anyone, I am always careful to avoid communicating ideas or messages or promoting events, products, or services or organizations that are inconsistent with my religious beliefs. So the majority viewed Colorado's potential ability to prevent her from having this kind of statement on her website as a form of compelled speech. What they said is the First Amendment can't control your speech, and they ruled that her advertising website itself was a form of speech. Sonia Sotomayor writes in dissent that this is not really about speech, but rather it is a form of discrimination, and she's really just trying to communicate her intent to discriminate. The case leaves us with some pretty significant questions. We don't know for sure how narrow or broad this ruling is going to be in the long run. It turns on the fact that this is a website design corporation, so it's kind of weird, right? Creating the speech is the business itself, but the objective conduct would itself also be a form of speech. Also, the case doesn't really deal with the question of religion. The owner of 303 Creative articulates this position as a religious belief on her part, and the court doesn't really tackle that element of the case. They really sit with the First Amendment speech element here. The other interesting thing about this case is the question of standing. The federal courts in the United States do not have a roving mandate to go out and hear any case that they want to. They have to have what we call a case or controversy. So there has to be a real party who has a real injury. And the question here was, well, okay, she's got this website, right? She wants to put a statement on it, but the Colorado Commission on Human Rights has not come after her. They haven't yet told her that she can't do this. She's suing because she anticipates that at some point she's going to run into trouble. And many people were saying, well, that maybe this was not a case where the court really had a controversy to address, but they did reach out to decide that case regardless. Another case that got quite a lot of media attention, actually two cases, were the cases addressing affirmative action in higher education. There was one case coming out of North Carolina that involved an affirmative action program at a public school, and then another case coming out of Harvard that involved affirmative action in a private educational context. For many years, these programs have managed to get over the constitutional bar by claiming that diversity in higher education is a compelling interest. In other words, the Constitution has a bar against racial discrimination, and in order for a policy to differentiate on the basis of race, you have to show that there's a compelling state interest in doing so. And the jurisprudence up until June of 2023 was that diversity was such an interest. And the court has ruled that for higher education, that no longer holds true, that race cannot be taken into account as a general rule in admissions in higher education. But again, here there are still some remaining questions. In the majority opinion for the court, which was written by the Chief Justice, John Roberts, he leaves open the possibility that schools can still do very targeted, individualized consideration of the role that race may have played in a person's personal journey. So you could have somebody write an essay for college application that talks about how their experience of living a raced life has affected their development and their interest in attending a particular institution. There's some speculation that he might have included that because he was influenced by a question that Ketanji Brown Jackson asked in the oral argument about this specific point. There's also a footnote that says, yes, this applies across higher education, public and private, but we're not going to tackle the question of military academies yet because they may have some different interests in play. We don't know also whether this reasoning is going to extend beyond higher education. And another interesting feature of these cases was the debate over how do we understand the 14th Amendment and the period in which the 14th Amendment was added to the Constitution in the aftermath of the Civil War. You have a really interesting debate going on in the separate opinions where Justice Jackson, on the one hand, is pointing out all of the ways that the Reconstruction Amendments were designed to address the destruction of slavery and the destruction of all of the aftermath of slavery in clearly racialized forms. Whereas Justice Thomas makes the claim that these amendments were intentionally written to be colorblind. And that if you look at the intentions of the framers of these amendments, they did not intend them to have any particular racial impact. So that will be worth watching going forward. I want to spend a minute on some cases that may not have gotten as much media attention. They weren't necessarily splashed all over the front pages of every major newspaper. And these cases involve controversies in Indian law. The first, Hayland versus Brackeen, involved a statute called the Indian Child Welfare Act. This statute provides that when a child is given up for adoption, if that child is of Native American ancestry or is themselves a tribal member, Native American tribes have to be given priority in adoption proceedings. A white couple, the Brackeens, who had done some work with foster children and wanted to adopt, had adopted one foster child of Native American ancestry and wanted to adopt that child's sibling, challenged the Indian Child Welfare Act on several different grounds. This case is a great one for people who teach constitutional law because it kind of has it all. The challenge was based in a violation of the Administrative Procedure Act, a claim that the statute itself was beyond the scope of Congress's regulatory authority under the Indian Commerce Clause and anti-commandeering. And they also threw in an equal protection challenge, claiming that preferring Native Americans over other races in the adoption process was a violation of the 14th Amendment. The case came out 7-2 in favor of upholding the Indian Child Welfare Act. The majority opinion was written by Annie Coney Barrett, herself an adopted parent, and she writes this opinion that allows the Indian Child Welfare Act to survive, at least for now. The ruling is very complicated, and it kind of breaks out all of these different charges against ICWA. And some of them the court did agree to rule on, but some of them the court felt there was not an appropriate plaintiff who had standing to challenge on those grounds. So on the question, does Congress have the power to pass this law? The court takes that question and says, yes, Congress did have the power to pass this law regulating the adoption process for Native American children. But the court specifically set aside the question of equal protection. Is this racial discrimination? Because they believed that no plaintiff in this case had the standing to bring it. There is indeed perhaps an injury that the Brackeens could claim. But the problem is that going after ICWA doesn't actually address the wrong that they're claiming to see, because it's the state courts and state administrative process that is leading to the outcome that they didn't want to have. Another really interesting thing about this case, though, is that Justice Gorsuch, while he joins the opinion and agrees with this outcome, wrote this concurrence where he really gets into his understanding of Indian sovereignty and the special relationship between Congress and the Native American tribes, and makes a real effort to write the states out of that relationship, which he sees as being very strongly between Congress and the tribes, and really articulating a stronger vision of Native American sovereignty than we have seen coming out of the court in quite a long time. If we look at another case involving Native Americans, there is a case, Arizona versus Navajo Nation. This one was 5-4. The Navajo Nation was involved in some water disputes with the state of Arizona, and they sued basically to bring the federal government into the conversation about their water needs based on a treaty provision from the late 1800s that had established a reservation. Fundamentally, what they were asking was for the federal government to look at this treaty and identify the water rights that it was protecting for the Navajo Nation. Had that happened, of course, they would likely then have gone on and asked the federal government to enforce those rights. The majority, however, found that the Navajos could not bring the federal government into this suit. That what they were asking for was too speculative, and that the treaty couldn't be used as a tool for this kind of action. And this ruling actually provoked a very bitter dissent by Justice Gorsuch. He frames it as just another betrayal on the part of the federal government failing to respect treaties and failing to take responsibility for enforcing those treaty rights. So we're seeing some really interesting developments in Native American law right now. There's some sharp disagreements on the court about how far treaty rights go, and some real disagreements about the nature of Indian sovereignty and how far the states can go in regulating and perhaps meddling in Indian sovereignty. There's also this really interesting configuration on the court itself, with Gorsuch being very far out there on the leading edge right now, pushing for a strong conception of Native American sovereignty and protection of Indian rights, with Justice Thomas being all the way on the other side of the spectrum. So I would just say, watch this space. Certainly water conflicts are not going to go away, so I anticipate there will be more litigation. Turning to another area of law that's been very active for the court this term, we've had some cases involving a national government authority, and in particular, how far can administrative agencies go in making regulations. If you were around for my talk last year, you'll remember that I mentioned that the court was going to consider another case involving environmental protection. That case did come forward and reach a decision this year, Sackett versus EPA. The case involves the Clean Water Act and how far the EPA can regulate under the Clean Water Act. And when this case was accepted by the court, I think a lot of people were expecting, oh, this is going to be another one of these where it goes 6-3 with a liberal conservative split. But when the case came out, it was actually 9-0 with Justice Alito writing the unanimous opinion. It's not quite as simple as that, but I'll get there in a minute. The background of the case is that you have this couple, the Sacketts, who have been fighting with the federal government for 15 years. They want to build a house on a lakeside, but in order to build this house, they had to fill in a wetland area that led to a creek that then went into a larger lake. And the EPA claimed that because this wetland would drain into the creek, which would then drain into the lake, they could not do this filling work. The justices agreed that this particular enforcement of the Clean Water Act was really too far. So that's how you get to the 9-0. Everybody agreed that the Sacketts had indeed suffered an injury to their property rights by being told that they could not build their house. But there is actually some disagreement on the court about what the proper test for regulating wetlands actually should be. You have 4 justices, including Justice Alito, who endorsed a test that the Commerce Clause, which authorizes the regulation of navigable waterways and other kinds of waterways, would only allow regulating a wetland that flows into water that is a channel for interstate commerce. So this little creek connecting to the lake didn't pass that threshold, and that's why the Sacketts won for that test. Justices Thomas and Gorsuch would have gone even further. They would have had even more limits on the EPA's capacity to regulate wetlands. And then you had 4 justices, Justice Kavanaugh plus the 3 liberals, who would have allowed a much more generous test that would have left more room to regulate wetlands. But since Sackett has been decided, you've seen the EPA pulling back on wetland regulation in a number of instances. A case that has likely attracted a great deal of attention among this audience is the question of Biden's student loan program. This one was one of those 6-3 decisions where you had 6 conservatives on one side and the 3 liberals on the other side. And the 6 conservatives agreed that the student loan forgiveness plan that Biden had put forward through the Secretary of Education was not going to stand. It was a major question. You remember that major question idea that I mentioned earlier. It was put forward under the HEROES Act, which is legislation going back to 2001. And the court just said, no, that there's not, the HEROES Act could not be read to authorize this program. There's a sort of interesting debate over standing in this case as well. One of the cases where you had individuals who had received loan forgiveness, but not as much as they wanted, they were found not to have standing to challenge the program. But a company that was servicing loans for the state of Missouri was found to have standing, and that was rather controversial. What's going on with this issue right now? The Biden administration has moved forward with a different plan. This one has been through more administrative processes under the Administrative Procedure Act, and it is going forward under the Higher Education Act. So there's some speculation that it will not be vulnerable to attack on the same kinds of grounds that led to the downfall of the earlier program. But of course, we'll see. A final area that I want to talk about in terms of the cases that the court has decided this year is the question of voting rights. Now, after last year's blockbuster term, people on the left were very concerned when the court put on its docket 2 major voting rights cases. Being worried that, okay, this is going to be the end of the Voting Rights Act. The court is just going to go in there and completely reconfigure the way that voting rights work in the United States. The first case, Moore versus Harper, involved a rather nasty battle over redistricting in the state of North Carolina. So you had a redistricting process that was challenged under state law. It went all the way up to the North Carolina Supreme Court, and the North Carolina Supreme Court said, no, this plan is unconstitutional under our state constitution. The legislature then defiantly put that plan back into place. And this debate ends up going up to the US Supreme Court, where the question was, who has the final authority to determine whether a question about redistricting is going to be decided. And the North Carolina Republican legislature was arguing that because the Constitution states that the times, places, and manner of congressional elections shall be prescribed in each state by the legislature, that they got to have the final word. The court, in a 6-3 ruling, with the opinion being written by Justice Roberts, said, sorry, North Carolina Republicans, you, the legislature, do not get to have the final word on what the Constitution means. State Supreme Courts remain the authoritative interpreters of state law and the authoritative people who get to decide whether a state law conflicts with the state constitution. And this is important because it eliminates the kind of scary prospect that a legislature could just decide to intervene in an election or in an electoral count and impose its will over the will of the voters. However, Roberts does kind of hold back a little bit of authority for the US Supreme Court, federal courts, because his opinion underlines the state courts' capacity to make these decisions, but then says the federal courts also have the capacity to oversee these decisions and determine whether there are any federal issues or federal constitutional issues. And this was striking because you actually see the court sidling up to the very controversial 2000 decision of Bush versus Gore as authority for this ruling. So yes, state courts get the final say, but they're subject to oversight from the federal courts. The other major voting rights case, Allen versus Milligan, you can kind of see, if you're able to see this, this graphic that I've got here. Alabama, like every state, went through redistricting in 2021, and the Alabama legislature, there had been a map that had been in use after the redistricting in response to the 2010 census. And it had 7 congressional districts, but in the intervening years, you know, you had shifts in population, and the percentage of Black voters in Alabama had increased substantially. However, the Alabama Redistricting Commission comes back with the map you see on the left, which you might note, there is a striking similarity to the map that you see on the right. Alabama Democrats call foul, they go to court, and they secured a ruling from a lower federal court that the map proposed by the Alabama legislature violated Section 2 of the Voting Rights Act because it diluted Black voting strength by packing African-American voters into one district and then dividing up all the remaining voters so that they would not be able to elect a representative. In 2022, that lower court ruling was appealed up to the US Supreme Court. Supreme Court said, yes, we want to hear the case, but they put a stay on the ruling that the lower court had issued. The lower court had said to Alabama, go back and redraw your districts correctly. The Supreme Court said, you don't have to go back and redraw your districts because we've got an election coming up, but we're going to hear the case. And the midterm elections go forward with the disputed map. And unsurprisingly, Republicans win 6 out of the 7 seats that are up for election, despite the fact that African Americans make up 27% of Alabama's population. However, when the Supreme Court decided the case, they looked at previous jurisprudence, and rather than, as they did with Roe versus Wade, throwing it out the window, they said, well, actually, we did get it right in those previous cases. And they found that the lower court had indeed applied the test correctly, and that the Alabama legislature was told, go back to the drawing board, literally, and redraw your districts in compliance with Section 2 as the district court had interpreted it. Just a little update on that case from a few days ago. The Alabama legislature went back and redrew the districts again, and guess what? The map didn't look all that different from the map that the lower federal court had thrown out. So a 3-judge panel ruled again that the districts were in violation of Section 2 of the Voting Rights Act. And just on Monday, Alabama has appealed to the US Supreme Court again, asking again that they stay the decision of the lower federal court and take up the question again of what they should do with their legislative districts. Do they indeed have to draw their legislative districts so that Black voters will have a reasonable opportunity of electing 2 rather than 1 of Alabama's 7 congressional representatives? Interestingly, it's been a busy period for the court outside of the courtroom over the last year. If you look at the 2022-2023 decisions, it's been a less flamboyant term for sure than 2021 was, but as I've gone through, there have still been some really major cases. There have been some questions about some of the cases that the court has chosen to take, some questions about how it's interpreting standing. But for me, there are 3 particularly interesting justices on the court for this year. As I've mentioned, Justice Gorsuch continues to solidify his reputation as the best friend on the Supreme Court. that Native Americans have ever had in history. Ketanji Brown Jackson has had a terrific first term as a Supreme Court justice. She's been very influential. She's been particularly active in oral arguments and has really made an impact. And it seems that Chief Justice Roberts has been more successful in pushing forward the court as an institution and defending it a little bit from controversy in the decisions that it has made. However, the court has not been immune to controversy going beyond what it is actually doing in the courtroom. If you're able to see this image, it might look a little bit weird to you. It is actually a painting featuring lawyers Peter Rutledge, Leonard Leo, and Mark Paoletta, along with Harlan Crow at Harlan Crow's resort in the Adirondacks. And of course, you see in the middle of this cabal in the painting, in addition to the statue of the Native American, our friend Justice Thomas. Over the course of the last year, there have been some very interesting and troubling revelations about Thomas's relationship with billionaire Harlan Crow. He has received a number of gifts from Harlan Crow that he's not disclosed. He went on a number of luxury travel experiences. Harlan Crow purchased the house where Justice Thomas's mother lives. So I guess in a way, he's kind of Justice Thomas's mother's landlord. And he paid for Justice Thomas's teenage grandnephew to attend private school. Thomas has said that they're really good friends. I don't have any friends like that in my life. I'm guessing none of you out there do either. There have also been some revelations about Justice Alito receiving some very nice fishing trips and other goodies from billionaire Paul Singer. And overall, there have been some revelations about Leonard Leo himself, who is a major funder for the Federalist Society, and his explicit attempts to influence the court. He received $1.6 billion with a B dollars to advance conservative ideology through the Federalist Society, and he has been spending that money. And indeed, this year, just a couple of tidbits, groups that he has funded filed briefs, amicus briefs in 303 Creative and in Moore versus Harper. So some interesting things going on. Justice Roberts has thus far resisted any effort to build a code of ethics within the court. And there have been some kind of angry rebuttals by Justice Alito to the idea that the court should have a code of ethics imposed upon it. So where does all of this leave us? What should we expect for the future in thinking about what has happened over the last couple of years? I expect there are going to continue to be voting rights controversies. I am not necessarily convinced that Section 2 is going to continue to persist in the form that it does. The Alabama response to the decision is pretty interesting to me, and the idea that they can just go forward and say, no, do you really mean it? Do you really mean that the district court got it right in that case? That's kind of shocking. I think we're going to have to see where the other shoe is going to drop with affirmative action. Is the scope of that really going to be expanded to include other state agencies, other state policies? What's going to happen there? We have a number of questions remaining about the administrative state. The court has already accepted certiorari for a case involving the Consumer Protection Bureau and whether that violates the Constitution's spending clause. The court has accepted a case that calls into question whether the federal courts have to show deference to agency interpretations of statutory mandates. And there's a case out there asking if people who go out and do testing for the Americans with Disabilities Act actually have standing to bring a suit to enforce those rights. So the idea is, you want to know if a law is being is being appropriately enforced, right? You go out and you say, I'm a person with a disability, I want this accommodation, and then see if the accommodation is actually provided. There's a question now as to whether that kind of suit can actually be brought if the tester is not actually experiencing a disability. I think these ethics questions are going to continue to simmer. And as I've noted, the court's standing with the public does seem to be in some question right now. In part, I think, because of the controversial nature of some of the cases that they've decided, and also because of these ethics questions that have been getting quite a lot of attention. But for me, the really big question, especially given that the Presidential Commission on the Supreme Court didn't end up having any sequel in the form of proposed legislation or further conversation about doing something about the court, curbing the court, changing the way justices are nominated, appointed, or their terms. The real question is, well, how are we, the people, going to respond to what's going on with the court? And I just want to close by reading you a quotation from Justice Sotomayor's dissent in 303 Creative. She writes, I fear that the symbolic damage of the court's opinion is done, but that does not mean that we are powerless in the face of the decision. The meaning of our Constitution is not found in any law volume, but in the spirit of the people who live under it. Every business owner in America has a choice whether to live out the values in the Constitution. Make no mistake, invidious discrimination is not one of them. So as I close, I would like to invite all of you to take up Justice Sotomayor's challenge beyond just the question of discrimination, and think about how you too might own the Constitution. Thank you.
Thank you so much. So we are going to now move. That was an excellent talk. We are so excited now to move into our question and answer. And we have some really great questions. This is still an opportunity for you to put questions in the Q&A. I'm going to launch into our first question. And our first question is actually from a faculty member in the audience who may or may not have sent this to me via text message. Thank you for this wonderful talk about the last Supreme Court term. I know there are many students in the audience who haven't thought much about the Supreme Court before this semester. They may be wondering, what does this all have to do with my life personally? Could you share one or two ways that you think the court's decisions last term might directly impact them?
Absolutely. Has anybody out there borrowed any money to go to college? If you have, I did too. Mine are happily finally all paid off. But yeah, Supreme Court has reached out to touch your life. The rulings involving affirmative action may have an impact on some people's lives. That tends to be more of a factor at very selective, highly elite institutions. We don't expect it to have a huge impact with our admissions processes here at UAlbany. But we have to think about how we're defining all of our programs. And we have to make sure that we're not doing anything that might cause us to come under scrutiny. Again, you folks are in California. I'm in New York. We're not living in states where these decisions are empowering state legislatures to do things like close down DEI programs, or that kind of thing. But that is happening in a lot of places in the country, and that absolutely has an impact on the daily lives of many college students.
Thank you. Thanks so much. We have several questions, but I do want to encourage, if there are students in particular in the audience who just need even clarification questions, please send those in as well. We're happy to ask as much as we can in our remaining time. So this question was, So after the Supreme Court overturns a district map, what happens, right? The question was, is there then an election to replace the people who were already elected with the map that had been overturned? What happens next?
They're in Congress. They are sitting there. Again, this
Yeah.
is a function of what happens when the Supreme Court decides how it's going to handle a case. So the map, we know, the district court said, no, this is not acceptable under Section 2 of the Voting Rights Act. You have to go back and you have to fix this before the 2022 midterm election. Supreme Court comes in and says, yeah, we think this is an interesting question and that there may be a problem with what the Alabama legislature has done, but we're going to pause that order that the lower federal court put into place. And we're just going to let the election go forward. And that's what happened. So you have those representatives in Congress representing the people of Alabama.
So our next question veers towards affirmative action and actually focuses on two of the justices, Justice Thomas and Justice Sotomayor, and this comes from one of our students. Justices Thomas and Sotomayor benefited from affirmative action at the university level. How have they influenced court decisions on the subject?
That's a great question. Very interesting question. Justice Thomas has consistently maintained that he did not benefit from affirmative action, that everything that he has achieved throughout his life has been a reflection of his success on the merits of what he has done. Justice Sotomayor, on the other hand, is willing to acknowledge that affirmative action programs have had an impact on her life. And she has been very explicit about what she sees as the value of her voice being in the room. If you go back to her nomination, one of the things that she discussed was how do things change when you have, as she called it, a wise Latina in the room discussing these cases and these opinions. And regardless of what you think about affirmative action, whether or not how it might have affected the lives of various justices that sit on the court, I and other observers do think that there may be something a little bit different going on now that Justice Jackson is part of these conversations.
Thank you. Okay, our next question is, you began this talk by mentioning that you are a political scientist. Could you say a bit more about how your approach to studying the courts might differ from a lawyer, for instance?
Absolutely. This is something that political scientists are very fond of talking about, so try not to bore you too much. As a political scientist within my little corner of political science, I'm really interested in the court, not just as a producer of legal doctrine, but as an institution and as a political institution. I and other people who come from this perspective don't really draw this distinction where, oh, you know, the court is legal and the presidency and Congress, those are the political branches of government. I do see the court as being political, but it operates in a particular institutional space as a court that is a little bit different than what you see in the other branches of government. Political science has also been really valuable in studying the courts because my colleagues who do different kind of political science give us a lot of the really rich quantitative analysis of what's going on with the courts. And they do these wonderful studies where they can kind of figure out how we map the justices in an ideological sense by looking at them in comparison with like a historical baseline of decisions over time, and then the decisions that they themselves are making.
So I would like to follow up with a kind of personal question that's sort of related to this, and it's about you and about how you found political science and found your path. So how did you fall in love with political science? How did you find this path? And as you went on this journey, what were the most important keys to success to becoming a political scientist?
I would not advise that anybody follow this path. So, be more rational in the way that you make decisions in your life. But when I was in college, I was in an interdisciplinary major that combined a little bit of history, a little bit of political science, a little bit of philosophy, a little bit of econ, a bunch of stuff. I had gone into college with the intention of becoming a lawyer because I was raised by my mother, who told me, you need to go out and train yourself to have a career so you can support yourself no matter what happens in your life. Like, okay, lawyer, that's a career. That counts, right, Mom? But while I was in college, as I was approaching the end of my college career, I was really interested in the idea of teaching. I really liked some of my professors, and I was thinking about going that route. I wasn't really sure though, so I took the GRE one weekend, and then I took the LSAT the next weekend. I was very indecisive, and I applied to both law schools and graduate schools. Ended up going to law school, and then did one of those summer associate jobs where you're going around doing lawyer things for the whole summer. And that confirmed my understanding that I did not want to be a lawyer. But as I was getting on in law school, I was realizing that the kinds of questions that I was really interested in were questions that I couldn't fully answer with the law school brain. So I ended up then applying to doctoral programs in political science. Wound up at Michigan, which was exactly the right place for me, and ended up with a career in political science.
And what kinds of resources, tools, things that were important to you to be successful? What do you think that were most important to make sure that you were successful on your path?
Really, the most important thing was great mentors, people to talk to, people who believed in me, even when I didn't believe in myself, and who were willing to take just a little bit of time to help me along my way. But that, I would say that absolutely that was the most important.
And I know here at Albany, we have some great mentors if you're interested in political science, studying administration of justice, the law. Dr. Michael, who's here, our administration of justice professor, Dr. Smith, who's also, in addition to being incredible mentor and guide, he's also a lawyer. So he has a lot of great guidance in a variety of different career paths. So think about your faculty and staff, lots of folks to lean on as so just sort of reaching out to students. Mentors are really helpful guides that can help you along your path and find a way. So thank you. That's a really great answer, and sort of opens the door to different kinds of paths. We like to ask that of folks who give talks for our students.
And actually, we just got another question in the chat. I'm going to jump ahead a couple of questions because this one just dovetails very nicely. And it says, what advice do you have for someone who wants to get involved, but wants to do other things as their career?
Again, a really great question. And I think absolutely the right one to be asking right now. Many years ago, a lot of people who wanted to be involved in legal change, you go to law school, you become a lawyer, you get into impact litigation. I don't think that is necessarily the only path to try to work for change right now. A lot of change is happening at the state level, not at the federal level. A lot of change is happening through legislation. And really, you can go all the way down to the local level, getting involved in local politics, trying to get your hands around what you can do to make your environment better and more just and more accountable. And you can do that in a lot of different ways. You can do that just by engaging in activism yourself, by becoming part of an organization that is promoting activism and not necessarily just through the courts, or by working within the government yourself. Right now, many states, I'm sure California is one of them, is really lacking in people who work for the state, who are coming in with the belief that good people in government positions can move the government to more just outcomes. So, look into those positions where you can use your talents and your skills and your passion and your democratic commitment to make the government do things that it should be doing and make the government do those things better.
Thank you so much. I want to move on to the next question, and I think this question speaks to the activist heart of a lot of our students, and this is coming from one of our students. What can we do as citizens to prevent laws like the one that banned abortion?
Again, a really great way of thinking about it. Why did we get the Dobbs decision? A lot of people were really shocked when the Supreme Court came in and said, all right, open season, states can do whatever they want about abortion, all the way up to banning it completely. And part of that, I think, was because the progressive left kind of slept on this. There were people who were paying attention and who were kind of ringing the alarm bell saying, hey, these state regulations are really bad. They're really having an impact. There are a lot of poor pregnant people and people of color who are not able to get access to abortion services. This house is on fire. But until Dobbs, it just wasn't really getting out there. So the biggest thing you can do is pay attention. Don't fall asleep. And when you hear the most marginalized members of your community saying, hey, this is a problem, that's the voice you really need to be listening to, because often these kinds of things are going to have the hardest and first impacts on marginalized communities. And they're just going to go from there. And absolutely push on the legislative aspect. In New York, we have efforts to pass legislation that codifies Roe versus Wade. So we are going to protect the right to abortion access, no matter what happens at the federal level.
I feel like one of the things that has become much more part of the larger discourse, political discourse, is a greater attention to state legislatures now and to state courts post Dobbs, and talking about not only what laws are being passed, but also antiquated laws that were on the books that all of a sudden came into effect because of Dobbs. All of a sudden you had laws that were passed, maybe even generations past, that were now all of a sudden legitimate as a result of Dobbs, correct?
Absolutely. I mean, one of the great examples of that is the attack on mifepristone or medication abortions.
Right.
One of the techniques used to attack is say, hey, we have a law dating back to the late 1900s saying that you cannot mail contraceptives in the federal mail. And oh, hey, guess what? That's around again. So yeah, you absolutely have to watch to see what kinds of older laws might be revived in this kind of environment.
To piggyback on that a little bit, do you feel like Dobbs has legs that can connect to or move into contraception? Do you feel like that's the sort of the next logical step with the court?
Unquestionably. We will be seeing, we may not see it at the Supreme Court immediately, but we're absolutely going to see those controversies popping up.
I feel like I teach modern American history, and I feel like although I look very youthful, I've been teaching for a while. And one of the things that one of the things that I talk with my students about is I think about the beginning of my career and talking about contraception and innovations in contraception in American culture in the 1960s and 1970s and its use, like the pill, right? And thinking about its presence even in pop culture, and talking about it today as a controversial point of discussion and how it's transformed, right? Just even in my own lifetime. And so thinking about how this is moving through in a post-Dobbs world. So it's a really kind of interesting development, certainly. Catherine, do you want to move into our next question?
Sure. So this one is probably mostly going to be your opinion, but it'd be great if you could maybe explain a little bit what this means as well. So it's, what do you think about court packing? Would having a closer split between conservative and liberal justices be better in some sense? And if so, how?
Yeah, no, that's a great question. There have been a lot of discussions around, okay, if we think the Supreme Court is broken, what should we do to fix it? Based on what I've seen from history, it is unhealthy to have a court where you have a really deep divide between conservative and liberal. It's not really good for jurisprudence. It's not really good for outcomes. It's not good for the court's legitimacy when it works like that. And I don't want to overstate. There have definitely been decisions this term where you've seen some really interesting alignments and splits. Like Gorsuch being with the liberals here and there. The occasional disagreement between or among liberal justices, but by and large, it is a problem. How do we fix it? Well, the two kind of things that are usually mentioned most frequently would be, one, adding seats to the court, have more justices on the court, and then the second option would be to figure out a way to impose some kind of term limit. And the number that has tended to float around among people who talk about these things is 18 years. So not as short as the House of Representatives or President or the Senate, but 18 years, long enough for somebody to have an impact on a peak institution like the US Supreme Court. At this point, we are in a period of extreme partisan polarization where you have Democrats and Republicans who are very, very much invested in their identities and are very far away from each other on the political spectrum. So the problem with adding seats to the court is that you're going to likely for the next several years to come have presidents who are using those seats to make appointments that are aligned with those ideological perspectives. Now, that would fix the current problem of balance. I don't think I'm going to say anything controversial by saying that the political orientation of the court does not reflect the political orientation of the country right now. So yes, you add seats to the court, do it at a point where you can give a Democratic president the opportunity to bring more justices in. You might end up with a court that looks a little bit more like the span of ideology in the United States. That doesn't fix the polarization problem. And the term limits proposal, I think, might do a little bit better job of addressing polarization, because everybody can then know that the seats on the court aren't going to just depend on random happenstance of when a justice dies unexpectedly. You won't have a situation where a one-term president gets 3 appointments. And there would be less incentive, quite frankly, for one party to play political hardball in every way that it can to hold on to the precious and unpredictable resource of a single Supreme Court seat. So I think some of these changes are going to have to be put into effect to get the court back on course, in addition to ethics reform.
Thank you, Julie. Could I just ask just a quick follow-up for some of the students in the audience, which is how would those changes actually happen?
That is the real problem. There's some debate about whether it would actually be constitutional to impose term limits, because if you read Article 3, it says in a very straightforward way that federal judges have lifetime tenure, and the only way to remove them would be to go through the impeachment and removal process, which we generally use somebody who's doing bad things. But there are scholars out there who believe that you could impose an 18-year term limit through other means. There's nothing in the Constitution that says how we have to structure the work environment of the justices. You could create incentives to get justices to leave the bench at a particular time. Okay, congratulations, Justice X, you were 75 years old. Here's your golden parachute. things like that. They all have clerks that work for them. You don't necessarily have to support clerks for a justice who is overstayed. They're welcome in the halls of the Supreme Court. So there might be tactics that could be used. Now, the other piece of this, and this is where we the people come in, is that there has to be pressure. There has to be pressure for Congress to take these actions. And I would agree that it would be nice to have that be a bipartisan agenda, because a broken Supreme Court doesn't serve anybody.
So our next question, actually, it kind of dovetails really well. And you mentioned this again, because actually at the beginning of the talk, and you're just in this last response, you used the word legitimacy. And a member of our audience asked, what do you mean by legitimacy? So can you speak to that a little bit?
Do we trust the court to be acting in the best interests of the American nation? Do we believe that they are doing their honest and level best to decide cases for the public good? Or do we think that they are basically just trying to tilt the scale in favor of their preferred partisan outcome? That's become an increasingly difficult question. And are they really acting in the interest of promoting the great project of American democracy? Or are they actively undermining the project?
And do you feel like, I mean, you spoke to this a little bit in your talk too, about the sort of more recent controversies around ethics, particularly with Justice Thomas and also with Justice Alito, right? But especially with Justice Thomas. And again, I also would agree that I would love to find friends that would buy homes for my parents to live in, or perhaps for me, or whatever, just throwing that out there to the audience. You can put it into the Q&A if you know someone. But do you feel like that is compounding this issue of legitimacy, or it's amplifying rather?
Absolutely. I mean, even if you don't follow these issues really closely, it is kind of galling to see this sort of thing going on. And for people who do follow it more closely, it is pretty disturbing to see Supreme Court justices acting in ways that would get them into enormous amounts of trouble if they were a district court judge, or
Right.
if they were a circuit court judge. I mean, these are the kinds of things that, you're like, all right, you're going to go spend some more time with your family.
Right.
You don't want to be.
Right. Is there, I mean, I was curious if you can speak to, is this something that is a more sort of product of our recent time? Is there a historical context or historical sort of continuity with this kind of behavior on the court? Or is this something that is a more recent development?
This seems kind of, I mean, yes, there have been justices in the past who've had relationships with other political actors, and justices who had relationships with powerful people. I mean, you don't
Right.
get to the point of
Right.
getting appointed to the U.S. Supreme Court without having these kinds of relationships. But this is really, this is a whole order or magnitude very different than what we've seen in the past. If we go back to the late 1960s, there was a justice on the U.S. Supreme Court, Associate Justice Abe Fortas, who was going out and giving lectures, and he was getting paid for giving lectures. And this came to light, and it created enormous controversy. And indeed, at the point when this broke, it was at a point when Chief Justice Earl Warren had just stepped down from the court, and then President Johnson wanted to elevate Fortas to the Chief Justice role. But not only was he not able to get that promotion to Chief Justice, the controversy became so serious that he had to step down from the court. And what he was doing was sort of like this in comparison to the reports that we're seeing right now. So there's a lot happening here. Just really quickly, 18 years, we have seen justices who've served significantly less than 18 years. The interesting thing is that recent appointments have tended to trend toward younger justices. Justice Kavanaugh, Justice Gorsuch, and Justice Barrett, they are really young for Supreme Court justices. So they're going to hang around for more than 18 years unless they have some sort of very unexpected health decline. And of course, Justice Thomas aspires to be the longest serving Supreme Court justice. He's actually getting pretty close to that mark at this point.
Thank you. Thank you so much. We are coming up to the end of our time. And so we just wanted to ask one final question. And you started touching on this at the end of your talk, but if you had to kind of choose, what cases where should we have our eyes for the next term right now?
I intend to watch two things. I'm really interested in what's going to happen with voting rights and with the Voting Rights Act. And I know it's not really sexy or exciting, but I think we need to keep an eye on what is happening with the administrative state and the ability of administrative agencies to make regulations that are going to address problems in American life, especially as we're moving into this period where climate change is creating situations that require rapid response and require responses from the federal government. You want to have administrative agencies that are going to be able to step in and do things on an emergency basis, or at least do things relatively quickly. And as long as we have a Congress that is not really able to come together and pass legislation often, that flexibility needs to be there. And there are several justices on the court who believe that it is a virtue for the system to be very slow and very inefficient in producing regulations.
Thank you. Thank you so much for a fantastic talk and really wonderful answers to all of these questions. We appreciate everyone in the audience for being here as well. We'd like to thank the ASL interpreters for their work as well. And as we wrap up, I am just going to quickly share our flyer for our next event, which is coming up in 2 weeks. It's on your screen now. This is actually an in-person event on campus, a film screening and then discussion with the filmmakers. Please keep an eye on your emails. We will be sending the trailer and a description of the film, and we hope some of you will be able to join us. So again, in closing, thank you all for coming today. And Julie, Dr. Novkov, thank you again so much for joining us.
Thank you so much.